The Use and Sales Tax Act exempts from use and sales tax marijuana growers. So how is it the property tax wouldn't do the same thing? Because it's recognized by the sales and use tax as being agricultural. So how would it change for property tax purposes? And quite frankly, it didn't. Welcome to A Higher Law, a cannabis podcast from the Dykema law firm. I'm your co-host, Carl Rashid, a member at Dykema and practice group leader of the firm's property tax appeals group.
And I'm Mark Magyar, a member at Dykema and a member of the firm's appellate and business litigation groups. For more episodes, you can find us at dykemapodcast.com, youtube.com/dykemalaw, or by searching, quote, A Higher Law, wherever you get your podcasts.
On today's episode, we'll be discussing a first-of-its-kind decision from my Michigan Circuit Court that could have big implications for the cannabis industry. So this particular matter involves a client of ours who came to us with the issue of whether their property should be classified for property tax purposes as agricultural instead of commercial, which the assessor insisted on classifying it. In looking at the statute and with the activity that's conducted on the property, which is the growing of cannabis plants or marijuana plants, it was clear, at least in our mind, that the growing of those plants fit as the definition of agricultural. So we took the very initial step, and that is to appeal to the March Board of Review for the township. And that's a very key step in property tax matters. In some instances, you need to go to the Board of Review in March. In other instances, you don't. For example, if it's an industrial or a commercial property, an appeal to the tax tribunal is not precluded by not appealing to the March Board of Review. But for a classification appeal, which does not go to the Michigan Tax Tribunal, you must first exhaust your administrative remedy by going to the March Board of Review. And that's what we did in this case. Typically, a Board of Review is comprised of 3 citizens of the locality. So these are 3 residents of the township involved who sit as the Board of Review. And for the most part, they seem to be well versed in terms of residential property and the values of residential properties. And that's typically what they have appearing before them, residential appeals. When it comes to a legal issue, of course, they would defer to either the assessor or the township attorney. And in this case, they deferred to the township assessor, who claims that the State Tax Commission advised him that this property, which grows marijuana on 80% of the property involved, should be classified as commercial because they also sell the product. So the Board of Review denied the application to change the classification, and by statute, we were then required to go to the State Tax Commission. And when we went before the State Tax Commission, we submitted a number of exhibits along with our petition to change the classification. The exhibits being, first of all, a license issued by the township allowing the client to grow marijuana, and also definitions of what is considered to be agricultural. Well, the State Tax Commission received a response on behalf of the township and, of course, on behalf of the Attorney General's office, or by the Attorney General's office, and they claimed that this property, by virtue of the fact that they do sell marijuana products on it, in addition to growing, should still be classified as commercial. And it's interesting what the State Tax Commission stated in the review. Basically, what they said was the petitioner did not show that it was growing marijuana, despite the fact that everybody acknowledged that it did, and despite the fact that there were licenses issued by the township allowing them to do so. And also they determined that the General Property Tax Act does not provide for a definition of growing marijuana to be included as agricultural. We then filed a motion for reconsideration with the State Tax Commission, saying we think you were wrong or you might have misinterpreted the law, but let's try to make it as clear as we can for you. And so we submitted in our reconsideration uh, a bulletin issued by the Michigan Department of Agricultural and Rural Development, and the publication was entitled Cannabis and Pesticide Use. And in that publication, it clearly stated in Michigan, cannabis is considered an agricultural commodity. So we thought at this time, by submitting that, and here's a department of the state of Michigan, which clearly defines cannabis growing as an agricultural commodity, that we would be successful. Well, again, the State Tax Commission said they were not persuaded, and therefore they continued to classify the property as commercial. Now, as Mark will tell you, we took an appeal from there, but let me just tell you the significance of agricultural versus commercial. Now, the reason we were seeking the agricultural classification was because property classified as agricultural is exempt from certain school tax millages. It's exempt from up to 18 mills for school operating purposes millage. So that's a pretty substantial amount if you can think about that. It's 18 mills by whatever the taxable value of the property is. In addition, as agricultural property, it would typically have a lower true cash value as opposed to commercial. Commercial property tends to be valued much higher because it sells for a greater amount versus agricultural. So the impact is both the exemption from the millage and the valuation of the property. So when the State Tax Commission denied our motion for reconsideration, again, this is our second request to them, we then appealed to the circuit court, and Mark took it from there.
Yeah.
Mark, I'll turn it over to you.
Thanks a lot, Carl. And, when I got the phone call from you, it was because of my practice or my specialty in appellate law and because we were doing an appeal. So I'll be the first to admit that I'm not a tax expert and I'm not a cannabis expert. But thankfully, at our firm, and regular listeners of this podcast know that the reason, it exists perhaps is because we have experts in those areas that I could lean on and work with. But I was brought in especially for the appellate aspect. And there's some interesting aspects about that because, for one, the statute that we're dealing with has a line in it that we've talked about that says these classification decisions are not reviewable after the STC. And we learned through our research that there was a Michigan Supreme Court case that said that provision is not constitutional because there are important property rights here that you have to have some kind of judicial review. So, and in that opinion, the Michigan Supreme Court sort of said that line is scratched out. You do get judicial review. So we knew we had a review. And then the procedure was you can appeal, unlike most appeals that people hear about that go to the Michigan Court of Appeals, this was an agency appeal. And agency appeals are special kinds of appeals that go to a circuit court. A circuit court you're used to is where it's the trial court level, where you're holding trials, but not in these kinds of appeals. The circuit court can act like an appellate court and be the appellate body. So we knew we were filing in circuit court. There was still another decision to make. The law provides that these kinds of appeals can be made in the Ingham County Circuit Court, because that's Lansing, that's where the state is, or they can be filed in the circuit court of the county where the classification at issue is. Here, that was Cass County, Michigan, which also just so happens to be where I grew up and went to high school in Dowagiac, Michigan. My dad is a retired solo practitioner in Cass County. I actually know a number of the individuals involved, including the assessor in this case for LaGrange Township. He is someone who I've heard his name many times before, just in my dad's work. And so we ultimately decided that we wanted to be where the property is located. And so we filed our claim in Cass County, Michigan, and that's the circuit court that was deciding this issue. At that point, the rules provide that even though we're in circuit court, it operates very much like an appeal in the Court of Appeals, meaning You, Carl, created an outstanding record below, and the circuit court is limited to that record. We're not putting in new evidence. We're not having a trial. We're not calling witnesses. This is an appeal. And by the time of an appeal, you have a record below that the appellate court is reviewing. And that record below was, Carl, your work to first ask the assessor to change the classification, and then appeal to the board of review, and then appeal to the state tax commission, and then seek reconsideration at the tax commission. So by the time you did all of those things, I had a very neat, tidy, I think it ended up being like 180 pages of documents of a record that you had created that I can then rely on and make my arguments from of why everyone below was wrong, and our client was entitled to have their real property classified as agricultural instead of commercial for the tax benefits that you just described. But another sort of, I wouldn't call it an obstacle, just a reality that we were dealing with is whenever you're on appeal, doesn't matter what it is, there's a standard of review that the appellate court looks at the issues. And in this case, in any agency appeal, but particularly in this case, the standard is very deferential to the agency. And so in this case, we had to show that the state tax commission made a decision that was quote unquote unauthorized by law. So not even just that they were wrong, that what they did was unauthorized by law. And our main two, arguments, and the one that I'll let you talk more after I'm done of what the implications and why it's so important. But the main two issues we brought forward were, A, there's no doubt in this record that we have established that we do indeed, grow and harvest cannabis. And when I say we, I mean the client, that their property. That really shouldn't have been in any dispute. And you mentioned the licenses and the other information that you had submitted in the record. But also the fact, and you referenced this, the fact that the STC came back with their denial and said, you, client, have not shown to us that growing cannabis meets the statutory definition of an agricultural operation, so therefore we deny your request. We took major issue with that. That was unauthorized by law, because essentially what the state tax commission did was put on the taxpayer, our client, the burden of proving to them what the law should be. And that's not a taxpayer's burden. That's for a court to interpret. Our burden is to show in facts what it is that we do at the property, which we did. And we brought that to the circuit court, and we said, it's your job, court, to interpret the statute. The parties have a disagreement about what the statute says, but it is so broadly written to include any agricultural operation. It doesn't define a list of things you can grow and not grow. It says anything that you're growing. And so we said, Your Honor, it is unauthorized by law, and it's arbitrary and capricious, which is another standard the court looks at to determine if something is unauthorized by law, to exclude cannabis out of personal preference or whatever the case may be, while you allow other types of things that aren't listed in the statute to qualify as agricultural. And the court agreed with that. And the opinion that we obtained on, I think it was June 29th of this year, was when the circuit court issued its opinion in our favor. The circuit court ordered the LaGrange Township to reclassify a parcel of the property as our client requested from commercial to agricultural. Now, there's still some litigation, even as of at the end of last week, percolating about that. There may be some more layers of review, but the initial decision was in our client's favor, and the main holding was that the STC's decision was unauthorized by law because the statute interpreted, and it's under its own plain language as the court must interpret it, would include cannabis as an agricultural operation. I won't get into the nitty-gritty of all the details of why. Once that determination was made, there's still a couple of things to look at of whether agricultural was the predominant use of the parcel, which it was, versus commercial, and some other factors that go into whether it can then be classified as agricultural. But the circuit court found that we met all of those things and ordered, as I mentioned, the lower agencies to classify that property as the client had and as we were arguing for as agricultural. So, I'll turn it back over to Carl if he wants to talk about the implications from a tax perspective. And he mentioned some of that already, or even for the industry going forward.
Yeah.
But that was the decision that we got on June 29th.
Thank you, Mark. Yeah, I was really surprised and disappointed, I might add, by the state tax commission. It appeared to me that they were trying to avoid the issue for some reason. And again, I guess the reason being the property taxes involved, which could be substantial depending on the taxable value of the property. Just to give you an idea, so for every $1,000 of taxable value of property, this would be an exemption of $18 in taxes. So that's a good amount. It's almost 40% of a typical tax bill. But having said that, the reasons they came up with, to me, were nonsensical. And I say that because, first of all, they're saying, well, we're not even sure that this company is in the business of growing marijuana. Oh, all right. Well, let's see. They had licenses issued by the state of Michigan. They were issued establishment license, Class C marijuana grower. They were issued licenses by the township, the village of Cassopolis, which clearly says it is a marijuana license, and the license type is adult use grow Class C to grow marijuana. And the other thing is, the Use and Sales Tax Act exempts from use and sales tax marijuana growers. So how is it the property tax wouldn't do the same thing? Because it's recognized by the sales and use tax as being agricultural. So how would it change for property tax purposes? And quite frankly, it didn't. And you did an excellent job in the circuit court, and the judge, to her credit, clearly interpreted what was a unambiguous statute. I mean, very clear. Is the growing of a plant considered to be an agricultural commodity? And she clearly found it to be that case.
Thanks, Carl. And I want to pick up on a point you just made about your disappointment and sort of unfair double standards. Part of the record of what you were doing in the agencies below, the first time the STC denied the relief, they said, well, you haven't shown us that the definition of agricultural operation includes cannabis.
Right.
So you filed your motion for reconsideration, which they accepted, and you provided them a publication from MDARD where it said cannabis in Michigan is considered an agricultural operation.
Right.
And they came back and said, well, that's not in the context of the General Property Tax Act, so we're not going to listen to it. Well, without the court opinion that we just got from the circuit court, there was no such definition or authority on the topic. So they were essentially putting you up to a standard that you could never meet until we took it all the way through this appeal and got the winning decision.
You're absolutely right. I mean, what they were basically saying to us, well, you're going to have to go to the legislature and ask them to amend the General Property Tax Act. So when they talk about agricultural operations for classification purposes, it includes cannabis or marijuana growing. And that's silly because it's there. It's already there. It doesn't need any type of an amendment, and it doesn't need any action by the legislature.
As the circuit court found for us.
Yes, exactly. So do you want to discuss what the next steps are in this case? I mean, I think we want to make sure that anybody listening to this podcast who's in this business of growing cannabis or marijuana understands that they're going to need to appeal that classification. If the assessor doesn't change that classification for them in 2024, and they'll know that coming up this coming February 2024, when they receive their notice of assessment, that they must appeal to the March Board of Review to challenge that classification.
That's absolutely right. And, I'm venturing a little bit more into your area than mine, but from this case, I've learned that a lot of those deadlines in terms of asking the assessor to change it, and if the assessor won't, then appealing to the Board of Review, and then appealing thereafter if you still don't get relief. Those all are first prerequisites to even getting to court.
Yes.
Because if you don't do those things, you don't get to court. And they also have deadlines that if you miss, then you've blown it. So to protect your rights all along, all the way, you've got to meet those deadlines.
Yep. Yep. You've got to exhaust that administrative remedy by going to the Board of Review in March, and then you have until June 30th in which to appeal to the State Tax Commission. And as Mark just stated, those dates are extremely important because if you miss one, you're out. There's no appeal. And by the way, even though the circuit court did rule in this case in favor of our client, it does not have any retroactive application to others. It's solely for this client. Would you agree, Mark?
I do agree, and I also want to make another caveat too: is if you're not in Cass County, whatever county you may be in Michigan, a circuit court, even an appellate circuit court opinion like the one we obtained, is going to be very helpful and hopefully persuasive, but it's not going to be binding. It's not like a court of appeals decision, which maybe we'll end up getting. Who knows, Carl? In this case, if the state further appeals and seeks leave to appeal from the circuit court to the Michigan Court of Appeals, only once you get to the Court of Appeals level do you get a decision binding on the trial courts of Michigan. So you could certainly obtain a copy of the decision that we obtained on June 29th from the Cass County Circuit Court, and you can certainly put it in front of a judge on your appeal in some other county, but it's not going to be mandatory until it reaches a higher court.
Right, right.
No pun intended for the podcast.
Okay. Well, I don't have anything to add at this point. Do you, Mark?
No, I don't.
Okay. So that's basically it for today, and we want to thank everybody who's listening. And as always, you can find us at dykemapodcast.com or youtube.com/Dykema Law, or by searching A Higher Law wherever you get your podcast. Again, my name is Carl Rashid.
And my name is Mark Magyar.
And we look forward to seeing you the next time on A Higher Law. Thank you.